Causing death by dangerous driving is a statutory offence in England and Wales, Scotland and Northern Ireland. It is an aggravated form of dangerous driving. It is currently created by Section 1 of the Road Traffic Act 1988, Statute. Section 1 of the Road Traffic Act 1988 creates the offences of causing death by dangerous driving, dangerously, see dangerous driving / dangerously, mode of trial. Causing death by dangerous driving is an indictable-only offence. Sentencing. A person convicted of causing death by dangerous driving is liable to imprisonment for a term not exceeding 14 years. Disqualification for a minimum of 2 years is obligatory on conviction. Endorsement is obligatory on conviction. The offence carries 3 to 11 penalty points. The Court of Appeal in R.V. Cooksley and others gave guidelines for cases where death is caused by dangerous driving. In R.V. Richardson, the Court of Appeal reassessed the starting point set out in R.V. Cooksley, taking into consideration the increase in the maximum penalty. The relevant starting points identified in Cooksley should be reassessed as follows. I. No aggravating circumstances, 12 months to 2 years imprisonment. E. Intermediate culpability, 2 to 4.5 years imprisonment. E. Higher culpability, 4.5 to 7 years imprisonment. IV. Most serious culpability, 7 to 14 years imprisonment. When a court disqualifies a person for causing death by dangerous driving, it must order an extended retest. History. Part 1 of Schedule 2 to the Road Traffic Offenders Act 1988 originally provided that a person convicted of this offence was liable to imprisonment for a term not exceeding 5 years. It was amended by Section 67 of the Criminal Justice Act 1993 on the 16th of August 1993 so as to increase the maximum term to 10 years. New offences. The Road Safety Act 2006 introduced 2 new offences of causing death by careless or inconsiderate driving, and a distinct offence for causing death by driving when unlicensed or disqualified. History. This offence was formally created by Section 1 of the Road Traffic Act 1972. But it was abolished by Section 50 of the Criminal Law Act 1977. Equivalents in other countries. Australia. In New South Wales and Western Australia, dangerous driving occasioning death is an equivalent to causing death by dangerous driving. The person's driving privileges in Western Australia will be suspended for at least 2 years from the date of conviction. Should any of the following circumstances of aggravation be proven in a trial for dangerous driving occasioning death, it is possible for the driver to receive a prison sentence of up to and including 20 years. Driver was unlawfully driving the motor vehicle concerned without the consent of the owner or person in charge. Driver was driving more than 45 km per hour over the speed limit, or person was driving the vehicle to escape pursuit by the police. If a defendant is tried in district court for dangerous driving occasioning death, but none of the circumstances of aggravation can be proven, the maximum imprisonment is 10 years. A conviction in magistrate's court can result in imprisonment of up to and including 3 years. In NSW, the maximum term of imprisonment for a conviction of dangerous driving occasioning death, 14 years. If the person's blood alcohol content was 0.15 or more, the person drove the vehicle at 45 or more km per hour over the posted speed limit. the person drove the vehicle to escape the police, or the person drove under the influence of drugs or a combination of drink and drugs. 10 years, if none of the above circumstances of aggravation was present at the time of the offence. The equivalent in Queensland to causing death by dangerous driving, dangerous operation of a vehicle causing death. Under Section 328A of the Queensland Criminal Code, the maximum penalties for this offence are 14 years if the driver operated the vehicle at more than 40 km/h over the posted speed limit, was under the influence of drink or drugs, knew or ought to have known that bodily harm or death resulted, and the death of the victim so results, but nonetheless failed to remain at the scene of the collision other than to obtain medical or other help for the other person before a police officer arrives. 10 years, if none of the above circumstances of aggravation is present. Driving disqualifications handed down by Australian courts, whether inside or outside Queensland, will result in the suspension of Queensland driving privileges. Disqualifications for dangerous operation of a vehicle causing death are included. Canada. In Canada, the Criminal Code has several road traffic offences equivalent to causing death by dangerous driving. The basic offence, dangerous operation of a motor vehicle causing death, has a maximum penalty of 14 years imprisonment. If the driver is convicted of failing to stop for police, criminal negligence, street racing, a hit-and-run, or drink driving, in addition to dangerous driving, and a death resulted, the maximum penalty is life imprisonment. A person's Canada-wide driving privileges will be suspended for any criminal code driving conviction, although lengths of suspensions vary by province and territory. In some cases, a driver's license can be taken away permanently after a certain number of criminal code driving convictions, as in the province of Ontario. Some provinces and American states have agreements to mutually recognize road traffic offenses that occur out of province or out of state. Traffic violations that occur in Michigan and New York for vehicular homicide accounted for license suspension purposes on a person's Ontario driving record. Vehicular homicide convictions in Maine and New York accounted on a driver's Quebec driving record. Ireland, an equivalent under Republic of Ireland traffic laws to causing death by dangerous driving, dangerous driving causing death. The maximum period of imprisonment for such a conviction is 10 years. The minimum license suspension is 5 years, due to the signing of the 1998 EU Convention on Driving Disqualifications among the British, Northern Irish and Irish governments. Convictions for dangerous driving causing death, in Northern Ireland, England, Wales and Scotland, accounted on a person's Republic of Ireland driving record. United States. In many American states, vehicular homicide is an equivalent to causing death by dangerous driving. Maximum prison sentences and license suspension lengths vary by state. Vehicular homicide, under the Commercial Motor Vehicle Safety Act of 1986, is often classified as a major violation, with the following minimum CDL suspensions applicable countrywide. For a first conviction, 3-year suspension from operating commercial motor vehicles designed to transport hazardous materials, otherwise 1 year. For a second conviction, lifetime, although 10 years if a state allows CDL privileges to be reinstated. Some states, such as Florida and Virginia, count out-of-state traffic violations, so long as they occurred anywhere else in the United States, the same as traffic violations that occurred in the state in which the driver was licensed. Vehicular homicide convictions are included. Other states, such as New York and Maine, counts them traffic violations that occur in Canada, the same as if those violations had occurred in those states. Vehicular homicide convictions are included. Permanent revocation of driving privileges is possible, particularly for holders of driving licenses issued in North Carolina and New York, after a vehicular homicide conviction.